Welcome to the Village in Howard. TBIH, as it's commonly known, is an organization for Howard County residents 55 and older. TBIH enriches the lives of county seniors to age in place, to socially connect with others, and to remain active as long as possible. This includes educational activities like this life planning series offered this fall. If you want to find out more about TBIH, you can talk to me after the Q&A or pick up a brochure on the table. Today we continue the 6th session TBIH Life Planning Series. Besides today's legal session, we had an overview session, and we will have other sessions on housing, aging in community, home care, and crisis navigating. We meet every other Wednesday at 10 a.m. here in the TBIH office. You can register on TBIH's website or call the TBIH office at 443-367-9043. You can register on TBIH's website or call the TBIH office at 443-367-9043. 9043. We hope you can join us. Today we'll cover and review legal-related documents, recommendations from an attorney, and helpful reminders for your post-retirement phase. Why do we need to plan this phase of our lives? Aren't we supposed to be retired and doing what we really want to do? We hope you'll see the reason to start or re-examine the legal parts of this plan to help yourself, your future caregivers, and your loved ones through this phase. I want to take a moment to make you aware of a new term. You've heard of aging in place. It's being replaced by aging in community. Aging in community is a broader term for aging in place. Aging in community emphasizes both keeping you at home and having you connect through social networks and community-based supports and services. Both terms may be used interchangeably in this series. So let's welcome today's speaker, Verena Meiser, an elder law attorney specializing in the legal aspects of caregiving and on how to plan for the transfer of your property to your families. Welcome, Verena.
Thank you. Welcome, everybody. It's a nice small group, so I will say that if you have a burning question while I present and it relates to what I just said, you can raise your hand and we can address it. Other questions we can defer to 30 minutes up into the presentation. So first, estate planning. Just to remind you why you would even want to estate plan. So everybody knows that if you buy life insurance, someday there will be money paid to your family, be it $10,000, be it $1 million. So it's something we can all relate to in a way. With estate planning, we also have an economic benefit because we preserve more of what we leave our family because we avoid unnecessary expenses, fees, taxes. So it's really good to do an estate plan. You end up saving money. It's just, we don't know the dollar figure that we save, but it will be something, plus the agony for the family. So we can go to the first slide. And here is the first place where you will save money. So most of you may be familiar with the fact that, there are powers of attorney out there and medical directives. And basically, these are documents that allow us to set up our support network in case we lose capacity. Because if we don't have these documents, our families have to set up a guardianship through the court. And you can guess that it's much more expensive to go to court and set up a guardianship. So even if there's no fight over the guardianship, no contest, it's at least $3,000 to $5,000 to set up a guardianship, plus it's not private because the court is involved in our affairs and monitors, and it's much harder for the family. You have the opportunity while you're well, like now, to set up powers of attorney to identify the people who can talk to your accountant and file your taxes for you in case you can't. Or they can access your retirement account, make sure you get your minimum distributions and get balance information and all of that. They can access your bank accounts and, write checks to pay your bills and all of that. They can even handle lawsuits. If somebody sues you or has to be sued on your behalf because of, say, medical malpractice, it's the financial power of attorney that has to start the litigation. So then you have medical directives to name the people who can talk with your healthcare providers, with your doctors if you can. So doctors have ethics rules and they have to talk with their patient. They will not gloss over you and go and talk to the person you name on the document. You can make the document effective right away to make it easy to use for your family. And you identify in our Maryland medical directive, which I like because it bundles 3 documents into one. You name the persons you trust with your health, and you can have joint agents in that context. It's just fine to have 2 or 3 children act jointly. And then you have the HIPAA provisions in there that allow your healthcare providers to share your private health information with that group of people that you identify. And you have the living will in there, which addresses your wishes towards the end of life. So all of us, because of Supreme Court rules that are out there in the whole country, we can determine in advance whether we want life support or not in 3 particular health situations. So one is what they call a terminal condition, and typically they will be cancer, and if the chemo and radiation doesn't work anymore, and we cannot communicate, because if you communicate, everybody will listen to you. This is only if you don't communicate. Then we can already say whether we want life support or not, and if we don't want life support, we can get into more detail. Do we want nutrition and fluids and all of that? If we were in a persistent vegetative state, some level of coma, and the neurologists just don't expect us to regain consciousness, same. And if we had an end-stage condition, which is typically a neurological illness where there's no cure, like Alzheimer's, MS, dementia, at some point that leads to death, we can also say in advance what we would like. And by you saying it in advance, your agents can advocate for you and put the foot down and make sure that that takes place. And you can even give your agents flexibility. So if you made a choice that your agent doesn't think is the best for you, it's not in your best interest, given the circumstances in the future, which we don't know today, it's hypothetical for us today, you can give them flexibility to talk with your doctors and use their judgment and just do what they think is best. And then there's some post-death instructions in our Maryland directive as well, so you can decide if you want to donate organs or your whole body to the anatomy board, or if you want to be cremated and buried, and all of those details can also be in the medical directive. And I like that because in some other states they break all these documents apart. So we can go to the next slide. All right, so I already mentioned that you pick, trusted family members or friends and authorize them to make health decisions for you. I encourage that you have conversations with that group of people, because the easiest way for them to help you is if they know what you consider quality of life or lack of quality of life, right? So the more you share with them your health concerns, the better they can relate to your situation and make a decision that you would have made. And it's also good to have these conversations with all of them together, especially if you have, say, 3 adult children. I usually, at the end of planning with the family, I have everybody come in and have a family meeting so everybody hears the same, so you then have one child saying, oh, mom told me this, and oh, mom told me that, and then there's a big discussion, right? So we go to the next slide. There's an additional form now in Maryland called a MOLTS. They're medical, so MOLTS is the acronym.
Turn off the lights a little bit, dim the lights.
All right.
Wait a second.
Just to adjust the video. All right. So since 2012, we have a second health-related form in Maryland that sometimes causes confusion because people don't realize that it exists, and it's actually mandatory. So by law, we have to have it in certain circumstances, like if we are diagnosed with an illness where we are expected to die within a year, or if we are released from a hospital to rehab, or we are in the hospital for an extended period of time, or we go to a nursing home and hospice, we must have our MOLTS. And the MOLS stands for Medical Order for Life-Sustaining Treatment, and it is signed by a physician, physician assistant, or nurse practitioner, not by us. We sign our advance directive, but the professionals sign the MOLS. And when they fill out the MOLS, they're not supposed to fill it out the way they want. They're supposed to talk with us and go into a conversation with us, and in the context of our specific diagnosis, ask us for our choices, explain what our choices are, note them down, and then sign it. So if you don't have the ability to carry out that important conversation with your doctor, it's your healthcare agents on your medical directive that will have that conversation on your behalf. So it's okay to let your family again know, when we would like to have a do not resuscitate, and if you had, kidney issues, would you want dialysis or not? If you have diabetes, would you consider amputation or not? All of those important matters have been collected on the MOLS, and the reason is that the nurses were very frustrated sometimes because family members would stand in the hallway and argue and be undecided and not know, how to decide, whether to or not to attach ventilator to their mother. And so the nurses really like to have a clear instruction from the boss, from the doctor, and so they like to follow the MOLS, and this is most states, all but 6 states in the country adopted something like it. So, in Florida it's a POLS, for example, and so on. But that's the idea. So you will one day meet the MOLS if you don't have one already, and it's your doctor's responsibility to present it to you when you need to have it, but you can always ask for it. If you already know you want it and do not resuscitate, ask your doctor. Okay. Now we switch from health to financial. So we all know that there's a lot of fraud out there, and banks continuously change their procedures for protecting our accounts, and it's really frustrating, especially if you use your phone and apps and all this two-factor authentication and what have you. You can imagine how worried banks are when a financial agent comes and wants to access your account, right? So the first thing is, I strongly recommend that you only have one agent act at the time. Bank of America, Sandy Spring Bank, they don't even look at a power of attorney that has co-agents, okay? So that's really important. And why? Because they want to know who's on the hook. So financial, we are lucky in Maryland because we have an enforceable power of attorney. It might be on the next slide, I don't know, it's not important. So I moved to Maryland in 2006, and at the time the estate planning bar was negotiating with the banking lobby, because often people would go to the bank with the power of attorney and they were turned down because the legal department looked at it and found some issue with it. So the result of the negotiation was an agreement for terms for a power of attorney that our legislators codified in 2012. October of 2012 was the first, 2010, sorry, 2010 was the first time. And it is enforceable because we lawyers promised we will not edit it, so the banks know word for word what comes in the door, and they already said we will accept that. So if they don't, they have to pay legal fees if there's a problem as a result of them not accepting it. So, and since 2010, the legislators add provisions every now and then. So if you have an older power of attorney, I suggest you update it. Just last year, October of last year, we had a whole set of additional provisions added to the statutory power of attorney having to do with gifting and having to do with updating beneficiary designations and representing you as beneficiary of somebody else's estate. So, it's really good to keep that document up to date. The law just keeps changing all the time. Now, one of the problems, of course, is we're not supposed to edit, and there's still some provisions that I think are missing in the document. For example, you want your agents to have a power to contract. So if they sign you into a nursing home, they are not personally on the hook. They can sign as your agent and pay with your money, right? So I think over time we will see those additions. So yeah, let me see, what else did I have here? Yeah, so financial powers of attorney, and I suggest if you have one, you already go ahead and take it to your bank so they see it presented by you and they make a note of it and keep it in your file. Rather than having your children or your spouse show up with it after you can no longer, because then if the bank has any question, you know, it's much harder to deal with it. And of course, financial agents are not personally responsible to use their own money. That's the whole point. You want them to be able to use your money. Okay, I think we can go to the next question.
Is a power of attorney different than just financial power of attorney?
It is a short form for financial power of attorney. Usually when we talk about power of attorney, we mean the financial one. So in some states, they call the healthcare one a healthcare power of attorney, which we call advance directive. So it's all just terminology. But if you hear people talking about a power of attorney, 99% of the time they will mean a financial power of attorney.
Do you have forms for the financial power of attorney?
So the statutory one, as I mentioned, was written by our legislators, so it's in our Maryland statutes. So, and I will have, the next slide will show you where you can get them. So just, yeah. So,
If I just had a power of attorney rewritten in the last month or two, it's got the new one in it.
I hope so. I don't know if your attorney, many attorneys don't update their documents, so you need to
Okay, I'll
make
have to
sure
look
you
at it.
check
All right,
on
thank
what
you.
your attorney, don't, you know, yeah. So this is about when the power of attorney goes into effect. And because you have a choice, you can say immediately, or you can say only after you lost capacity with regard to everybody other than your spouse. Your spouse can be immediately, but maybe your adult children, not until you lost capacity. So if it's contingent on your incapacity, we call it springing or contingent. And I usually recommend to have to require at least one physician's certificate where the physician evaluates your capacity to make financial decisions, because that also gives your child the benefit of hanging on to that document. If you become forgetful and you tell them one day to do something and they go ahead and do it, and then you forgot that you told them and you get angry at them, and then there's all this relationship issue coming up, right? It's good for the child to have this certificate in the hand because they can tell themselves, well, I acted to the best of my knowledge in Dad's best interest, and Dad just is forgetful, you know, so then at least it helps your child a little bit. If you want to have real protection, you can require two physicians to evaluate your capacity, but that's up to you and depends on who you are naming as your agents. Okay, we can go to the next page. And I will come to your question in a minute. So, because financial agents worry about liability, since they're fiduciaries, so they have to act in the principal's best interest, they have to protect the principal's property, and so they don't want to be left in a situation where they have to handle something and that the power of attorney doesn't clearly spell out that they can do it. That's why I think the power to, you know, for example, access online information, digital assets, or to maybe even deal with the pets, or pick up mail at the post office. If you're bedridden and something needs signature at the post office to pick it up, then your agents can go and with the power of attorney that, you know, an additional separate power of attorney and pick that up. So we give clients like a second power of attorney that has the power to contract and all of these other powers. And we can go on to the next. Okay, where can you get the documents here? So you can get the statutory form online. I just would suggest that there are some choices that have to be made are not, it's not that obvious what the best choice is. And it is really worth it to maybe go over it with somebody who has experience, like an estate planning attorney, because you don't want to make a wrong choice and end up causing some situation that ends up costing the family money. So, and you want to, you know, be well protected but not overprotected. So it's kind of experience on how these are used and how it plays out goes a long way. So that's why, you know, I suggest that to avoid guardianship, because if the power of attorney that you fill out is not correctly filled out, the family may have to still go to court and get a guardianship. So you want to make sure it's done well. Next page. Okay, so now we will add one more document to the mix, and that's a will. And really, everybody, including those people who have a revocable trust, they still need a will. Everybody should have a will. And even the people who have beneficiary designations on all their accounts and life insurance and retirement accounts, and they know everything will go straight like to their children without probate, they should still have a will, because what if the beneficiaries die before you? Suddenly the beneficiary designation fails and the property will go through probate. So the will has to be there as a backup. In addition, in the will, you name your personal representative, which is our terminology in Maryland. Some people call it executor. It's the same thing. Just we call it personal representative. And that's the person who is authorized to sign your last income tax return, for example. The IRS will look for their signature. So if you have no trust and the will is your main document that has your distribution scheme in it, you know, how you want to distribute the proceeds from the sale of your house and your brokerage accounts and all of that, then the process of administration is through the Register of Wills in the county where you live. So if we live in Howard County, it's our Register of Wills. And the person you name as personal representative goes to the court, opens the estate, and we call all of that probate. And the court then has a timeline for them. So after 3 months, they have to tell the court the date of death values of all your accounts and the value of the house. And then 6 months later, they have to file an accounting. And so the court has deadlines that they impose, and one just has to follow them. A lot of people hire an attorney to help them. The court is in Howard County is wonderful. You can get a lot of help from them too. But that's the process. And if you go to the next page, I know we are not worried about minors, including my children are all grown and have grandchildren. So, but if you have children who have minors, like your grandchildren, encourage them to have a will, because especially in Maryland, all they need to do in the will is name the guardians for their children in case something happens to both parents. So even if they have no property yet and they think, oh, I don't need a will, I don't have anything. If they have children, the will is a great place where they can both agree on which grandparents or which aunts and uncles or siblings and so raise their children if they cannot. And it's much better the parents themselves make those decisions than have the family have a big tug of war in court, and again it gets expensive. And it's a really hard decision. I mean, we all want to raise our own kids, right? And we've all done it, so it's hard for them. But it's better they address that tricky question. Yep. Okay, so other than that, as I already said, you can lay out your wishes in terms of you pick the personal representatives who would be the people you would trust with managing your assets. So once the court appoints them, they can go to your bank and they can go to like Vanguard for your brokerage account, and they can, maybe sell your house. So you're authorizing somebody who gets things done, meets deadlines, is good in accounting, and is honest and communicates well with everybody else. So it's the perfect person, right? But I think even if you don't have the perfect person, something that goes a long way again is to have a family meeting at some point while you're well, and let everybody know what your wishes are and what your expectations are, because you can tell them you come back and haunt them if they don't do it right. So so also, they can, if they know who your accountant is, that also helps, because if you have an accountant or a financial advisor, they know something about you too. So it's a team of three. It's like the attorney, the accountant, and the financial advisor. And let's say one of them retires, then the others can make recommendations, and they know your family. So it's really good to have a little team. And I know a lot of my clients, including me, use TurboTax. So don't have an accountant. But I think at some point it's good to establish a relationship with an accountant just so you can vet them and see if you like them. Even if they don't start doing your taxes yet because you want to do your taxes, you can help your spouse maybe if your spouse survives, or your children. And this actually for your children. When you have all your estate planning documents in a binder or somewhere in your house, keep 3 years of income tax returns. Because if your children then have to go to an accountant, a brand new accountant, they usually want to see the last 3 years of income taxes paid by the person who just died. And it's also important for the personal representative to know that you paid your taxes, because they are personally responsible for your taxes if you haven't paid them. So it's really important. Being a personal representative with regard to income taxes is a serious matter. Okay, next one. So all of this is probate. I already mentioned, you go to court, you open the estate, file inventories, and there's certain deadlines. There's some costs. They're not huge. Our register of wills, for example, had eliminated the fee for a small estate, which is under $50,000. Then one has to file a notice in the paper to let creditors know that you passed, because that gives them a time window to file a claim, and if they don't, they're out of luck forever, and that gives closure, right? So then they cannot come back 3 years later and ask for the money. So it's an important process. Okay, next one. Okay, I mentioned earlier there's other ways that you can avoid probate so that your will may not have to be used. For one, you can have a joint account with somebody. I caution you, if you're married and you have a joint account, that's one thing. Having a joint account with a child is fine, but you need to think about the possibility that your child might get sued. Maybe they cause a car accident and they're found negligent and there's a lawsuit against them. They're going to go after that account if their name is on it, even though it's your money in it. So be careful having your children as joint owners. It's better you have the power of attorney and go to the bank and tell the bank, my daughter Susie can write checks on my account and she can get balance information, all of that. That's better than adding Susie to the account. Beneficiaries, we all know from retirement accounts, insurance, and so we have beneficiaries. So those assets get distributed straight to the beneficiary. They don't even go through court, so our will doesn't even do anything. For real estate, there's something called the life estate deed. So I look at it as a way of designating a beneficiary for real estate. And real property interests can be divided. We already know that they can be split between multiple owners who can simultaneously use it. You can also divide real property interests in time. So you can say the present interest is mine until I die, and after I die, after that event, my son gets the house. So it's a future interest, okay? A life estate deed accomplishes that. So it says, I will keep the house, I live there for free, I pay the property taxes just like I've always done, and at the end of my life, when I die by operation of law without any other action, the house belongs to my son, okay? So that's also a way to avoid probate. And again, the will has no control over that. It happens. And then the son can go and sell it the day after or 10 years later. It doesn't matter. It's there, the house. They have to pay property taxes, of course. There are different kinds of life estates. I'm not going to go into that. And that's for people who are concerned about needing Medicaid, long-term care in the future. They need a certain type of life estate deed, but that's a different topic. If you have beneficiaries on your brokerage account, for example, it usually turns into a TOD, which is transfer on death, or your bank account payable on death. In Maryland, you can even designate a beneficiary for a car as long as it's paid off and owned by one person. You do it by going to My MBA, where you also can renew your registration fee online. And you go to My MBA and search for vehicle beneficiary, and it'll take you to a page where they ask you for the title number and your driver's license information, and then you can designate a beneficiary for the car. For $20, they send you a new title that shows your name, TOD, so like Verena Meiser, TOD, and then at the bottom it says beneficiary name on file, and then the beneficiary beneficiary just goes with your title, proof of insurance, and your death certificate to the MBA, and they get the car in their name. Again, the will doesn't do anything. Thank you. So here we go a little bit into protection. I wasn't going to talk about this too much, but if your spouse, say, has been diagnosed with dementia, you may want to leave property to your spouse in a trust that protects from the spouse's potential creditors. I think that goes a little bit beyond what I wanted to go, and it certainly if you have a child or somebody with special needs at the bottom, don't have them lose their benefits because you just left them an inheritance. Make sure that either you set up a special needs trust for this grandchild, or if their parents already set it up, find out what the name is of the trust and then have their share flow into that special needs trust, because it's the instant somebody on benefits, like a child with autism or so, receives an inheritance, they lose their Social Security and Medicaid and everything. Okay, we go to the next slide. Okay, so another way to avoid probate, and we're at now 30 minutes, so I'm going to go real quick and then I'll open it for questions. So I mentioned earlier revocable trust. So a revocable trust is really just an alternative to the will. It contains your instructions for how to distribute everything. The only difference now, if those instructions are sitting in your trust instead of the will, is that the family who administers it, your trustees, don't go to court. So I always tell people we never found out what Elizabeth Taylor owned, because she had a revocable trust. So all of this, everything you own also is private because nothing gets filed with the court. It's private, easier on your adult children if they have really busy lives and they have to be trustees and sell your house as trustees. They can pick the time to do it. They don't have 3 months deadlines and 6 months deadlines imposed by the court. So that's one of the benefits of trust. The other huge benefit of a revocable trust is if you own real property in different states, if you die with the will, one has to open probate in each of those states. So if you have a beach house in Delaware, there would have to be the main probate here and another ancillary little probate there for that beach house. So more work for your family. So it's really good to have a revocable trust if you have multiple real properties. Revocable trusts don't protect from your creditors at all, and they don't save taxes. It has nothing to do with taxes. In fact, the IRS completely ignores the revocable trust. And that's because you have total control over the property that's in there. You can add property, remove property, you can make investment decisions, you can even change the trust, the instructions by amending it or restating it. So the IRS ignores it. You still get your 1099 from your brokerage account after you moved it in the trust, and so all the tax obligations, but also the tax benefits. So when you die, you still get a step up in basis and all of that. So I think the next slide just shows the picture with the trust here. So and then with the trust, often you have assignments too. The assignments take all your tangible property, like your jewelry and furniture, and says it's all in the trust. That way it doesn't go through probate. So that's, that's the picture if you have a trust. And I think since the time is up, I should open it for questions. If anybody has a question.